Good day, everyone. I'm ANGELIQUE and I will be taking you down our answer. The question assigned to us is, examine how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process. In examining how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process, it will be helpful to first understand fundamental rights. So, what are fundamental rights? Fundamental rights differ depending on the context, such that the European Union, the EU, uses it as a term to describe human rights. For one, the EU fundamental rights are derived from multiple sources and used to cover a wider international human rights landscape, although it does not guarantee human rights in other contexts. In comparison, the UK has the Human Rights Act 1998, HRA 1998, that incorporates the European Convention on Human Rights into domestic law. It provides legislation of the UK to be interpreted along the lines of the ECHR, although it would be more accurate to say that the foundation of such rights have been developed along the centuries. Human rights are now protected by statute and common law, and it is the court's duty to interpret the Parliament's will accordingly.
Hello, I'm Brendan Hugh, and I will be discussing what exactly is a rights-based conception of law. This conception, otherwise known as rights-based constitutionalism, has its beginnings in a series of essays by the late Sir John Lawes. In them, he placed fundamental rights at the forefront of the factors that courts should consider when passing judgment on cases involving said rights. Sir Lawes was of the opinion that these rights should triumph over all other considerations, that they were so-called higher order laws that were of such status and importance that even Parliament in their supremacy could not overturn them. This Kantian perspective emphasizes that the autonomy of the individual is the ends to be achieved, not a mere means to one, thereby placing individual autonomy as the primary object with little regard or room for other considerations and consequences that may arise from this narrow focus on rights protection. Similarly, Ronald Dworkin describes it as an assumption that citizens have moral rights and duties to each other and political rights against the state. These moral and political rights are recognized in positive law and may be enforced at the insistence of citizens through the courts or other similar institutions. The rights-based conception of law may be contrasted with the more traditional rule book conception. The former, as espoused by Sir Lawes, places such importance on rights that it mandates a purposive interpretation of the law by the courts, while the latter does not, instead preferring a literal reading in line with legislative intent as embodied within the words of the statute. This expansion of the court's role from applying the law as passed by Parliament to purposively interpreting it may result in a blurring of boundaries between the judiciary and legislature, potentially undermining the doctrine of separation of powers as originated by Montesquieu. This purposive approach to interpretation will lead to judges passing judgment according to their own moral standpoints, transferring lawmaking powers from the democratically elected Parliament to an unelected judiciary, threatening democratic legitimacy. Besides this, the courts, in taking an active role in the protection of rights, would act as a check on the exercise of executive power, bringing the rights-based conception firmly under the broader red light theory of administrative law. It is thus argued that if rights-based constitutionalism is applied, the courts would inevitably act as the guardian of fundamental rights. However, this conception of law does not accurately reflect reality as evidenced by case law. The cases of Ex parte Smith, Ex parte B, Samaru, and Ex parte Anufrijeva were all decided not on the basis of fundamental rights, but instead on second-order considerations. These considerations include the appropriate standard of scrutiny by the courts on policy decisions, deference to expert bodies on complex issues, and the standard of administrative conduct. However, the courts, despite basing their judgments on these second-order considerations, did recognize the increasingly important role that rights play in influencing judicial decisions. This conception has thus resulted in a great amount of confusion among members of the judiciary as to the extent of their powers, namely in the area of judicial review, and whether the exercise of such powers would be in line with constitutional principles, such as separation of powers and parliamentary sovereignty. Nonetheless, the drawbacks of the conception are not sufficiently serious to entirely displace its merits. These issues may be resolved through a modification of the current rights-based conception with the concept of legitimacy as a qualifying principle. Rights-based constitutionalism may be a useful starting point for the courts when considering cases involving interferences by public bodies of the fundamental rights of individuals. This will grant the courts the necessary flexibility to safeguard fundamental rights within society and promote individual autonomy. Thank you.
Now that we are done explaining what a right-based conception of law is, let's move on to understanding what judicial review is. Judicial review is the process in which courts control and monitor the government's use of power and authority given to them by the parliament. Judicial review does not apply to private bodies, but it does apply to bodies exercising power analogous to those of governmental bodies. Any bodies which are governmental in nature, including local authorities, governmental departments, state agencies, tribunals, should exercise their powers in a lawful manner, as they will be subjected to judicial review if they acted beyond their given powers, in other words, ultra vires. Judicial review concerns the legality of the decision made by a public body rather than the merits of the decision on whether it is unjust, right, or wrong. Courts tend to focus on intermediate matters which relate to the questions of constitutional structure and decision-making propriety rather than primary questions relating to justice and morality. Therefore, the application of rule of law is exemplified in democratic society through judicial review. So, with judicial review, the courts can ensure that these four principal objectives are met. Firstly, judicial review can ensure the correct interpretation of the acts of parliament, which means that the will of parliament will be observed, thus upholding parliamentary sovereignty. Secondly, judicial review can ensure the lawful exercise of the discretion conferred to public bodies by the statutes. Third, it ensures fair action by the decision maker. And lastly, judicial review can make sure that there is no violation of human rights by the exercise of the powers by public bodies. Subsequently, the role of the courts in judicial review is for the judges to make certain that any exercise of powers being delegated to minister, administrative, as well as adjudicatory bodies is lawful and kept within the confines of the power conferred to them by the common law principles developed by judges and by the Act of Parliament. The application of judicial review can be seen in the cases such as Hatfield and Minister of Agriculture, Fisheries and Food, where a minister's discretion to refuse an investigation had been subjected to judicial review because the refusal would frustrate an act's policy. Furthermore, in the case of R against Secretary of State for the Home Department ex parte Venables, the Home Secretary was subjected to judicial review by the courts for unlawfully taking into account public opinions and failing to consider the progress of the teenage killers of a child when determining the length of their sentences. Moving on, let us examine what the prerequisite for judicial review is. Essentially, if an individual wants to bring an action for judicial review, the individual needs to pass the sufficient interest test, which means he or she needs to have sufficient interest in the particular matter to have permission and locus standi to bring an action for judicial review. Individuals who claim that their rights were infringed will be provided a hearing under judicial review. And in the case of R against Inland Revenue Commissioners, ex parte National Federation of Self-Employed and Small Businesses, NFSSB attempted to challenge the Inland Revenue Commissioners' grant of tax amnesty to the Fleet Street's casual workers on the grounds that it was illegal. However, the House of Lords ruled that NFSSB did not have sufficient interest and lacked locus standi to challenge the revenue's decision with regards to another group of taxpayers. Hence, this case has established a sufficient interest test where the approach of House of Lords in considering whether someone has locus standi should be examined in two stages. First stage, standing should be considered when permission to apply is sought. According to Lord Scarman, the court is concerned to ensure that this will prevent abuse arising from busybodies, mischief makers, and crimes. After the permission has been granted, the court in the second stage can revise its initial decision and decide that the individual doesn't have sufficient interest when the merits of the case have been known.
Hello everyone, I'm NAREENDRA and I'll be talking about the grounds for judicial review and the remedies and how they correlate with fundamental rights. Firstly, I'm going to cover illegality. Illegality as a grounds for judicial review occurs when the decision maker must exercise their power with a degree of discretion and a potential error occurs. The case of Regina and Secretary of State for the Home Department ex parte Sims, where a prisoner was deprived of his fundamental rights by the prison authority, the courts ruled that the order by the prison authority was illegal on the grounds of veteran decision. Where fundamental rights were protected in this case was when the court ruled that the order was not meant to undermine fundamental rights due to ambiguous words. Next, I will be talking about irrationality as a grounds for judicial review. Irrationality is a ground for judicial review where the courts, rather than testing the legality of the decision, are substituting their own merits into the decision. There are two parts to this grounds for judicial review. Let me introduce the first part, Wednesbury unreasonableness. The case of Council of Civil Service Unions and Minister for Civil Services defines unreasonableness as so outrageous in its defiance of logic or of accepted moral standard that no sensible person who had applied his mind to the question to be decided could have arrived at it. The standard for unreasonableness is difficult in protecting fundamental rights, as demonstrated in the case of Regina and Secretary of State for the Home Department ex parte Bride, where the courts ruled that the power used by the decision maker was reasonable, although it may violate the fundamental rights as described by the ECHR. It is noted that during this case, the ECHR was considered but not applied. Another case that demonstrates the failure of reasonableness is in the case of Regina and Ministry of Defence ex parte Smith, where the courts ruled that the decision of the Ministry of Defence was not unreasonable, as the policy was supported by both houses of parliament and by the minister's professional advisor. However, the court state the following: the more substantive the interference with human rights, the more the courts will require by way of justification before it was satisfied that the decision was reasonable. In this case, this factor was satisfied. The second part to irrationality is the doctrine of proportionality. The doctrine of proportionality is a grounds for judicial review where the limits of the exercise of power to means which are proportionate to the objective to be pursued. The doctrine is used most commonly in correlation with the protection of fundamental rights. This is demonstrated in the case of Huang and Secretary of State for the Home Department. In this case, it was found that the Secretary of State acted ultra-vires by means of proportionality and Article 8 of the ECHR. The doctrine of proportionality is better suited used with fundamental rights as compared with other grounds as stated by Lord Coke in Regina Daly and Secretary of State for the Home Department, where he states that the reasonableness is retrogressive and proportionality and necessity are more relevant to be practiced by the judiciary. The case of De Freitas and Permanent Secretary of Ministry of Agriculture, Fishery, Lands and Housing sets out the rules for proportionality, where the courts must: number one, the legislative objective is sufficiently important to justify limiting a fundamental right. Number two, the measure designated to meet the legislative objective are rationally connected to it. And number three, the means used to impair the right or freedom are no more than is necessary to accomplish the objective. This approach, however, was commented in Huang and Secretary of State for the Home Department, where this approach omits an important aspect of proportionality, namely the need to balance the interests of society with those of individuals and groups. The final grounds to judicial review is procedural impropriety. Procedural impropriety is a ground for judicial review where it is found that natural justice and fairness has been deficient. This ground, as of late, has been utilized less as there are safeguards in place to protect fairness. A case that demonstrates that fundamental rights is protected through these grounds is in the case of Regina and Army Board of Defence Counsel ex parte Anderson, where the courts ruled that the Army Board must achieve a higher standard of procedural fairness and the appellant had the right to be given a fair trial. This case was prior to the enshrinement of the ECHR, namely Article 6 of the ECHR, into the law of the UK by virtue of the HRA. This case demonstrates that common law has always protected one's right to fairness through common law. Post-HRA, the case of Bank Mallet and HM Treasury demonstrates how, with the availability of the HRA, courts apply the provisions of the Act in relation to using the grounds of procedural impropriety for judicial review. In this case, it was held that the Treasury was in violation of Article 6 of the ECHR and the appellant should have been able to make representation before the action was taken against them. Finally, regarding the remedies offered by judicial review are as follows: quashing order, prohibiting order, mandatory order, declaration, injunction, damages, default powers, and finally, the most relevant in regards to fundamental rights is the declaration of incompatibility with the HRA. So now I'm going to talk about the approaches to administrative law. As mentioned by Brandon before this, there are two approaches to administrative law, one being red light and the other being green light. The red light approach is when there is more intervention from the courts to review decisions from the administration. It is noted that this approach is important in administrative law as the lines between separation powers are blurry. Those who follow this approach believe that the primary function of administrative law is to control the excesses of the state powers and subject it to the rule of the law courts. Green light approach is when there is less intervention from the courts on the powers exercised by the administration. It is said that this approach minimizes the influence of the courts. The courts are an obstacle to progress, and the control over the administration was undemocratic and unrepresentative. The need for more efficient government will be a situation where the state is in a time of unrest. The case of ex parte Bride demonstrates this, even though the order by the executive could be said to be in contravention with convention rights. The judiciary decision to uphold the order was because of the state of the nation at the time, and that there should be less intervention by the judiciary. Lastly, before I leave, I want to talk about ouster clauses and how the courts circumvent them to protect fundamental rights. With parliamentary sovereignty comes the ability of the parliament to exclude or restrict judicial review. This is by placing ouster clauses on any legislation. For the red light approach to be effective, the administrators must be subjected to the rule of law by the courts. Parliament can issue ouster clauses in acts passed to bar the judiciary from reviewing the powers of the administration. By virtue of case law, in the case of Anismic Limited and Foreign Compensation Commission, the court ruled that courts had the ability to circumvent ouster clauses. The decision in Anism was made before the UK had joined the European communities, where now they are subjected to the rights under the ECHR. The case of Regina and the Investigatory Power Tribunal, where the courts determined that Section 67 of the Regulation of Investigatory Power Act 2000 does not bar the judiciary from reviewing the actions of the administration when acting under the provisions of the Act. In this case, fundamental rights under the ECHR was protected by the actions of the judiciary.
Hi, I'm Kynan. After having discussed the various grounds of judicial review on which the protection of fundamental rights are sought, let us examine the influence of the Human Rights Act 1998 towards judicial review applications. Judicial review as a mechanism to keep executive and public powers in check is enhanced by the incorporation of the rights under the ECHR through the Human Rights Act 1998 into the UK domestic law. Under the rights-based conception of law, judicial review is a necessary pathway by which individuals seek justice to vindicate the rights to which they are entitled. The case of Secretary of State for the Home Department against Nasri aptly demonstrates the influence of the incorporation of convention rights towards judicial review processes, wherein it was established that the focus of the courts should shift from the mere procedural aspect of the decision made to the protection of the applicant's convention rights. The case of K against United Kingdom further demonstrates the influence of the Act, wherein the European Court held that Article 8 of the ECHR was breached. The roles of the judges proved to be of further importance due to the nature of and issues arising from the Act, some of which will be discussed shortly. Playing a central role in achieving this end is Section 6 of the Human Rights Act 1998, which imposes a statutory obligation for public authorities to act in alignment with convention rights. Whilst it may be contended that public bodies had previously had duties to safeguard individual rights, the expansion of the scope of judicial review through the Act becomes apparent when the definition of public bodies under the Act is examined. This is owing to the fact that a new category of public authorities have arisen from the Act. Section 6, sub 3, paragraph B of the Act provides that such bodies include any person certain of whose functions are functions of a public nature. This means that whilst previous claims of judicial review could only be made against public bodies, now such claims can be made against even private bodies whose functions are of a public nature. While against Birmingham City Council and others serves as a great example of the impact of whether certain bodies are considered as public bodies towards fundamental rights. Interestingly, the issue surrounding the lack of protection of individuals against private bodies is mitigated through the inclusion of the courts themselves as public bodies. This would mean that the courts have a general duty to protect rights of individuals provided for under the ECHR, notwithstanding whether the body infringing upon such rights are public or private bodies, or whether their functions are of public or private natures. Additionally, analogous to the sufficient interest test mentioned by ANGELIQUE is the requirement that an applicant must be a victim of the act purported to have breached convention rights. A point of contention arises as to whether the doctrine of parliamentary sovereignty has been compromised with the introduction of the Human Rights Act 1998. This contention cannot be true in a theoretical sense, as it is in fact the parliament which has allowed for the enactment of such a statute. What follows is that the interpretation and application of the 1998 Act is but the court's upholding of the parliament's will, therefore reinforcing rather than diminishing the presence of parliament and the doctrine of parliamentary sovereignty. On a practical level, however, the Human Rights Act 1998 has attained a constitutional status so as to be considered as a constitutional statute. This becomes of significance when considering the inapplicability of the doctrine of implied repeal towards the Act. Still, the theoretical significance of the doctrine of parliamentary sovereignty necessarily means that the Parliament's expressed intention could amend or repeal any such provision within the Act with which it finds itself to be in disagreement, thereby overriding the contention that the doctrine of parliamentary sovereignty has been compromised or infringed upon by state statute. Another point of contention, one which has been previously mentioned by Brendan, is that the doctrine of separation of powers has been infringed upon by allowing the courts to judicially review, scrutinize, and nullify executive decisions under the purported cause of protecting fundamental rights, those provided under the Convention or otherwise. This issue is further compounded by the fact that the judiciary is a non-elected body, exercising judicial functions which may take away from the powers of the executive and legislative branches of the government, in whom the electorates have vested power. Indeed, this may lead to what Dworkin terms as an objection from democracy. However, he also takes the stance that judicial review applications may be necessary in a democracy. This could be understood in the view that the dignities and rights of citizens ought to be protected under democracies, which is what judicial review applications seek to do, to protect the fundamental rights of individuals from the unfettered powers of the government and other public bodies.
Hello everyone, I am Ong Jun. Much of the discussion involving the courts and judicial review towards rights-based conception are based on the Human Rights Act and common law. Although judicial review has played a big role in determining fundamental rights in the United Kingdom, there have been signs calling for support for departure from the Human Rights Act and welcoming the common law as a method of protecting the Human Rights Act from being marginalized in state. As of late, judges themselves seem to prefer using common law for protection of human rights over statutes. For example, Lord Reed and Lord Mance individually state their support on common law as an important primary source of fundamental rights and values outside of the court. This has been suggested as a method of preparing for the future, in essence, the possibility of a nation after repealing the Human Rights Act for a new Bill of Rights. This view has not only been supported locally. The United Nations, for instance, recognizes the rule of law and human rights as sharing an intrinsic relationship. According to the Dicey's principle of rule of law, the few limbs are: no man is punishable or lawfully made to suffer unless a breach of law is made, equality before the law, and rights being safeguarded by the law. It was proclaimed in the United Nations report that the rule of law requires legal processes, institutions, and substantive norms to be consistent with human rights, including the core principles of equality under the law, accountability before the law, and fairness in the protection and vindication of rights. This directly correlates with the second and third limb of Dicey's rule of law, such that it ties back to judicial review being a mechanism to ensure that justice is dealt with in terms of human rights breaches. However, common law might not always be the best solution, for it does not cover situations extensively like the Human Rights Act and European Convention on Human Rights would. The European Convention of Human Rights requires states to take responsibilities for protection of people's fundamental rights from interference, whereas the common law is only able to offer redress for some fundamental rights. Further, challenging the powers of public authorities via judicial review through common law is limited. For a claim in breach of a convention right would enable the courts to go as far as considering whether the decision has a legitimate aim and the proportionality of its impact. This makes the claim under statute far more powerful than a common law claim. It should also be noted that the theoretical practice of parliament sovereignty in relationship to judicial review by the courts has been suggested to be separated from practice. Nowadays, the courts have exercised power in judicial review far beyond within the theoretical limit granted by the Parliament. RN Panel on Takeovers and Mergers ex parte data fin was a case where the Court of Appeal held a non-statutory body wielding immense power to be amendable by judicial review. The crux of the argument focuses around power granted by the courts to interpret the will of the Parliament under parliamentary supremacy, yet being able to exceed the power given by giving its own decision. This argument was brought up again in ex parte factum, where it was now questioned how the Parliament could be considered supreme if it is subjected to the control of the European Union courts and to the UK courts through the European Union courts, in terms of European Union law. A remedy in place to counter this contradiction is the Declaration of Incompatibility, where judges only have the power to declare a certain statute or decision incompatible with human rights. However, the involvement of the Human Rights Act in recent times have caused some judges to question the constitutional status of Parliament's sovereignty and its relevance. Lord Steyn opined so in Jackson and Attorney General, stating that Dicey's take on Parliament's sovereignty seems out of place in the common world. Lord Steyn further considered how an exceptional circumstance leading to an attempt of abolishing judicial review should not be allowed to happen, for it is a constitutional fundamental. Although such claims have not been further explored within the case itself due to no relevant issues to the consideration above, it is a question subject to debate. Recently, the Judicial Review and Courts Act 2022 was passed in April, now providing the courts the power to award suspended and prospective-only quashing order, as well as making decisions of upper tribunals no longer eligible for judicial review. While it does address certain presumptions raised while the bill was considered during its drafting phases, it could still make significant changes to remedies available and what that can be challenged in a judicial review case. For instance, the removal of the upper tribunal's eligibility could be an issue of procedural fairness, which is a core aspect of judicial review that has not been addressed. What that can be concluded from such an act receiving royal assent is that the courts have begun assessing reforms towards judicial review procedures and remedies. Although the impact of such an act is not clear yet, it does show that the Parliament is concerned with judicial review by the courts. In due time, perhaps the role of the courts as guardians of fundamental rights via judicial review would be further clarified, be it by way of statute or by the courts themselves, especially in terms of the impact the Human Rights Act has towards present law. Thank you.